So welcome everyone, it's Grant Abbott from Lightyear Docs and also Abbott-Family Lawyers. We're going to be looking today at SMSF Wills and BDBNs, or Binding Death Benefit Nominations. You'll find generally my preference for any estate planning, and let's face it, an SMSF Will or BDBN, either one is a legal instrument. Hear that again. It's a legal instrument that deals with the passing of a deceased member's superannuation benefits from the fund to either a dependent or the legal estate. First up, Section 62 of the SIS Act provides that the sole purpose test, which is what essentially is encapsulated within Section 62, is that it must be, any death benefits must be paid to a dependent or alternatively the legal estate or the legal personal representative, which is absolutely crucial. Legal personal representative there is obviously going to be the executor or the administrator of the estate. You cannot, under any stretch of the imagination, put in that it's to be paid to the trustee of the estate, because that is not the legal personal representative. In fact, there's been a case on that whereby the death benefit or the purported binding death benefit nomination was held to be essentially invalid as a consequence of the relevant binding death benefit nomination, because it had been paid to the trustee of the estate. So again, if you've got any questions, let's go through it today. But Section 62 talks about dependents. And when we go into the definition of dependent, essentially that includes the spouse and includes children as well. So this is for the SIS Act, the payment of benefits out. On top of that, would include anyone who is a financial dependent as well. So financially dependent is a case in point, and we'll be looking at that a little bit later on. So for that perspective, let me actually have a look at that particular issue, and we'll cover a whole range of the dependency. So let's just move on and compare an SMSF will, which is essentially a BDBN on steroids. Now, I've built it in such a way such that it can fit in with our, so it still can fit in with any trustee which may be out and about there. So let's go down and have a look here on our slides. The first thing we need to know around binding death benefit nominations anyway, they essentially were built for retail and industry superannuation funds. In short, those sort of funds, and I remember when I worked at Rothschild, I was a trustee of the Rothschild staff superannuation fund. We had a number of death benefits would come up to us, and then we'd require to go out and search for dependents who may potentially benefit from the deceased's superannuation estate. So it's quite a detailed process. And then in Section 59 of the SIS Act, Section 59(1)(a), was built provisions for binding death benefit nominations, which are essentially a contract between the trustee of the fund and the member as to how their benefits are to be paid. So again, a trustee cannot provide, can't give its discretion away or its powers away, but it can in this one instance in Section 59(1)(a) for a binding death benefit nomination, which is then found in SIS Regulation 617 and 617A, and there's quite a lot of stuff around that as to what can and can't be done, two witnesses signing, so on and so forth. So that sort of overcame the issue around the discretion that was inherent for a trustee as to the payment of a deceased member's superannuation benefits in an industry or retail fund. And of course, that got litigated. There was more than 10,000 superannuation complaints tribunal cases just around death benefits. And that SET is now effectively AFCA. So from that perspective, where do SMSFs sit then? Well, essentially, if you have a look at the legislation, section 59(1)(a), where it does bind trustees of superannuation funds, it does have an exclusion. And of course, the exclusion there is in relation to self-managed superannuation funds. So what we need to do is that whole concept in the superannuation laws excludes self-managed super funds. So in effect, the laws regarding binding death benefit nominations doesn't have any superannuation law around it. It's for a self-managed super fund, it essentially is, it's all irrelevant, as is a lot of the laws that might be found in the SIS Act in relation to registrable superannuation entities. Now, therefore, again, the large industry and also retail funds, so they have no consequence down at the SMSF level. And then again, there's also a number of rules at the SMSF level. For example, a classic one is that all members must be trustees of the fund, which I don't agree with. I think that's a crazy way to run a fund. And I'm doing an article at the moment to come out in Self-Managed Super Funds magazine saying that we should minimise as best as possible the number of trustees that are residing in the fund, notwithstanding how many members there are. And we can do that through the utilisation of enduring powers of attorney. Likewise, on death of a member, all members must be trustees, but SIS Regulation 17A 3A enables the executor of the deceased member, excuse me, I'm in Adelaide, got hay fever. The executor of the deceased member or the legal personal representative to act as a replacement trustee or replacement director on the corporate trustee. So they can be in there representing the deceased member, the deceased member's estate, obviously, the superannuation benefits, and again, subject to any SMSF will, or if there's an appropriately documented and effective binding death benefit nomination, looking after that, provided, of course, there's a mechanism to put that person in as a replacement trustee. And in the light year docs, I've got that as an automatic process. So as soon as a member dies, their executor is, if they have a will, obviously, which is pretty important, their executor comes in and effectively becomes a replacement trustee on their behalf. We've even gone down a bit further, and that when it comes around to the payment of death benefits, whether it's in accordance with a binding death benefit nomination or not, that the only trustee, or if it's a director, corporate trustee, that can make decisions around the payment of those death benefits is the trustee, the replacement trustee. So that stops a lot of the fights that we see in Donovan, in Katzman versus Grossman. There's a whole range of cases there where there's fights between different family members or, second wife, first children, etc. So I've put that in there to really bolster that up. And that's crucial, so that, look, if you're not running on a light year docs deed and all the strategies there, in particular around estate planning, it's a good opportunity to obviously upgrade the deed and also upgrade the corporate constitution. If you want to go down that track, you can upgrade, I think, the deed and the corporate constitution to have all those juicy estate planning benefits, the SMSF will I'm going to carry on, plus a lot of other stuff. For $129, that's for both upgrades all in one. So, look, you can't get anything better than that, really. So let's have a look at where SMSF sit and SMSF death benefit just from a general perspective. Certainly from a superannuation member, we should know, so Phil Scandizo, what happens when the executor is already a trustee of the SMSF? Then she is still, that's a really good question, because she will take control of two things. So if you have a look at our deed, I can't tell you, Phil, about anyone else's deed because ours is pretty specific. But what will happen is she'll have her own benefits, but she'll also be in there. You don't need to appoint her as a replacement trustee. But when it comes down to dealing with the deceased member's benefits, effectively she'll be the one who's in controlling and deciding what to do, which can be very, very powerful if there is discretion available. So we might have, for example, John Smith, Sally Smith, his wife, Adam Smith, Max Smith, his son, and Janine Smith, his daughter, and they might all be in the fund. In fact, we could have Max's 2 children, Ben and William, in the fund once we go to the 6-member rule early next year in 2021. So in that instance, if they're all trustees, they'd all have one vote, or they'd all be able to vote as to what happens to death benefits, which can have a huge impact on discretionary payments. But notwithstanding that, if we have those payments going out and Sally Smith, the spouse, is acting in accordance with the deed, or certainly the light-year docs deed, then she will have full control as to how those death benefits are to be paid, if that makes sense. So the other members of the fund don't have that same amount of control. Whereas if you look at a standard SMSF deed from, Clear Docs or whoever, they don't have that oomph in there as to what happens in the event of the replacement trustee. So it's all too well to have the replacement trustee, but essentially what you're really looking at doing there is also to add the capacity for them to be the only ones who are making a decision in relation to the deceased member's benefits. So that's a pretty powerful one. Now, again, we've got a pension account and accumulation account. So for the pension, we again have to look at what the deed says. And this is important because if the deed actually says that when a person dies, that their pension ceases or their membership ceases, then effectively that pension is commuted. And then if it takes a while to come out, so you'll see a little bit later on, Regulation 621 says that death benefits must be paid as soon as practicable. So if there's a pension there and there's no reversion, so it's just a straight, one person pension, then effectively on death, if the deed says that the pension ceases or membership ceases, it's all to go back into the accumulation account. Now, the worst thing about that, it should really be in a sub account, because if membership ceases and there's a sub account, and let's say there's $1 million, just for example, that is standing in that account, in the pension account, then that moves back to the accumulation account. And let's say it takes 1.5 years for those death benefits to be paid out. Now, as soon as practicable, should be as soon as practicable. But anyway, it takes 1 year to be paid out. No earnings, nothing can be paid on that deceased member's account, because once it's there, the member ceases, it has to be locked in. If you make a payment of any earnings in there when the deed says it's actually ceased, then that is actually taking money away from other members' accounts and would be breach of the sole purpose test. So again, you've got to be really careful. An alternative, obviously, is where you have a reversionary beneficiary. So that is the pension just continues on to the next reversionary beneficiary in the event of the death of the member. So it's an automatic payment. So, for example, John Smith has a pension and it reverts to Sally Smith. Then in that instance, as soon as John dies, the pension continues, but now Sally is now the named pension owner of that. And of course, the 2 children, if Sally's not around, you can actually make both Max and also, and certainly not Max's children at this stage, we'll look at it a little bit later, Ben and William, but Max and also Janine as the 2 key beneficiaries. Now, they're going to be over age 25. So as a consequence of that, you can't continue the pension on, but the pension will go in and it will be commutable. So effectively a lump sum will flow out of that pension. I want to show you what to do with that a little bit later on. Again, it's going to depend on what the trustee says. Another little strategy I put inside the deed is, if you go back and have a look up on that second bullet point, that if pension or membership ceases, then the pension heads back to the accumulation account, which is obviously a disaster because you end up with, you lose your taxable component, tax-free proportions in that pension will go back and flow into any other stuff sitting in the accumulation account. Your tax-free or that tax-exempt portion that relates to pensions obviously gets cut off at that point in time because you can't continue the pension. There is an ability, again, in the capital gains tax laws that the pension exemption does continue, but if the deed says that membership ceases, then you can't rely on that law. It was very surprising when they introduced that. They didn't really focus in on the deed or the SIS Act's consequences. So what we've got in there is, notwithstanding the fact that as soon as a member dies, then we appoint the replacement trustee, and then they are treated as the member or the pension recipient until such time as all super death benefits are being paid. So that pension continues on in force. So it means it retains all of that stuff, also retains that tax exemption. So if you've got money sitting in your pension, you can pay out of there or commute if you needed to be paid out to, for example, Max and also Janine or even Sally, if it's non-reversionary. So if there's no reversion in there, this gives still some extension of time for that pension to continue. So that's an absolutely imperative strategy. Again, I can only just say what I've built in the light year docs deed and certainly haven't found it in any other deeds. So it's pretty important to have those criteria and those strategies built in there. So again, what's going to happen with a SMSF? As I said, SIS regulation 621 requires the trustee fund to pay out all death benefits as soon as practical. I've seen some go up to 3 years. Never seen the commissioner take action on that or auditors do a contravention report. But look, as soon as practical seems to be as soon as practical. Ideally, it should happen straight away. And this is a crucial element. So if we go back to the sole purpose test, again, paying to the legal estate, as soon as we do that, you've heard from me enough, it's going to be subject to the family provisions claim. So that's the last place we want to actually transfer our superannuation. In New South Wales, there has been a case, Kelly versus DeLucci, where you'll find the family provisions claims don't apply to superannuation funds, and in particular, benefits being paid out of those superannuation funds. The one exception is potentially the notional estate concept, which resides in New South Wales only, where effectively the court can look through a self-managed super fund and potentially attack SMSF death benefits, which may be paid out as a lump sum. Not a pension, but it paid out as a lump sum. Again, giving the strength to why we'd like to have reversionary pensions in our armoury. In the Kelly versus DeLucci, look, I've written a number of articles on this. I believe it was incorrectly decided. The solicitors in the case obviously didn't have any SMSF experience or very little SMSF experience because they should have really argued constitutional law, because what we've got there is the Succession Act in New South Wales seeking to override the SIS Act, which is a federal act. And in that way, Section 19 of the SIS Act provides that once you tick off that you're a regulated super fund, that effectively the Commonwealth laws apply. So one day they'll do that. Chris, you asked if there's a recording. Absolutely. So there'll be a recording up later on today that we'll send you out, and that'll be in in our strategy centre. So again, what's going to happen with the fund will depend on the exact deed. And I want to go through a couple of ones that I play around with. Again, as I said before, if a current pension's in play with a reversion, then it's continued. Although it is quite strange, I have seen a couple of commentators or a couple of lawyers who shut down reversionary pensions in satisfaction of a BDBN. Now, remember, a BDBN doesn't apply because there's no superannuation laws around it. So it has to rely on, obviously, what is embedded in their deed. I've had a look in their deed. and it does shut it down, which obviously has impacts on components and accumulation, as we saw before. So you really need to go through and see what your deed says. From that one, I'll come back to James. I'll have a look at that one a little bit. I'll have a look at it now. So I've got a question here from James Barger-Bross. Good to see you again, James. And of course, there's no, obviously it's a big question. So James from Finance-Wise, a member age 60 with account-based pension passes away. BDBN states the trustees can elect to pay auto reversionary. Well, that can't apply. You're either reversionary or not. So it'll be a brand new pension for that one. Member had no children, but was chronically ill for decades, and brother and sister, also members of the SMSF and co-executors, cared for him, cared, cleaned, took to the doctors, etc. His pension was paid into a partnership account to pay for housing, food, etc., and he received a small amount into a personal account. Won't the pension be auto-reversionary on the dependency and dependency basis, but who decides? So it's an old now Infinity Trust deed. If it's one of my old ones, you'd be okay. But I do know View Legal came in and embedded their deed in there, which, look, I can't do anything there. What I would say there, and that's a really good question, James, is that are the brother and sister dependents? Now, you'll find actually there's criteria. Dependent, obviously, is what the legislation says. So that's a SIS Act. The second one would include the spouse and include children. So that's not in this case here. It also includes interdependents, anyone who's in an interdependent relationship. So, for example, if people care for him, then I would say 100% that you're probably going to see that both the brother and sister are dependent or going to be in an interdependent relationship with a deceased, such that any payment when it comes down, because this also applies under the Income Tax Assessment Act, such that any payment out would potentially, if it's going to a definition of a dependent, which includes someone in an interdependent relationship with a deceased, would mean that any taxable component would come out tax-free. So if you want to send me, I can do a bit of research on that as well. And that's what we're here for essentially at Like Your Docs, is to make sure that we can handle all those sort of questions for you. So what do your deeds say? What I might do is I might just jump out of here for a second and just take you to a couple little places. I want to make sure there's plenty of time to get around everything. So if I have a look at here, there's a really good guideline from the Commissioner, and you can see that up on the screen there. Let me just blow it up a little bit further on. This is the ultimate determination as far as I'm concerned, and really puts all the stuff I said before into true context. So for self-managed super funds, is there any restriction in the SIS legislation on a self-managed super fund trustee accepting from a member of binding nomination of the recipients of any death benefits payable? So no. Now this is important. Section 59 of the SIS Act in Regulation 617A of the SIS regulations do not, let me just, might as well highlight that so that you can see, do not apply to self-managed super funds. So although I said it before, don't listen to me, listen to the Commission of Taxation. And there's quite a lot of law around that one. And in fact, there's been some cases on this as well. This means that the governing rules of an SMSF may permit members to make death benefit nominations that binding the trustee, whether or not in circumstances accord with the rules in 617A. So 617A doesn't apply. So we then go down and let's just have a look at, I think the date of effect is okay. Let's just go down to the explanation. And this is really important. So have a look at this anyway. I'll put this in our strategy centre with the recording of this, also a copy of the SMSF Will that I'm about to do for you. And also want to be in a position, I'll put this guideline and also the slides there for you as well. So you've got a really good foundation. So that as you go down the track and you're building these sort of things, you've got a good foundational experience. Anyway, so let's have a look at the payment of death benefits from a superannuation fund is determined. Oops, oh, you know, this will highlight anything. The payment of death benefits from a super fund is determined in accordance with the governing rules of the super fund, and here, not in accordance with the terms of the deceased will. If I asked, let's say, if I asked 600,000 members of SMSFs whether their super is looked after by their will or their superannuation fund, I would say that 599,990 would probably say that it is a function of their will. Now, that's important because remember, for those of you who know my concept of putting a moat around a client's benefits, the last place I want to see is monies moving out of the super fund and into the estate because of family provisions claims. So we want to make all direct payments out of the superannuation fund. I'm going to show you how to do that fairly shortly. The second sentence there says trustees of SMSFs cannot abrogate their responsibility for making decisions in exercise of their fiduciary functions, except as authorised under the governing rules of the trust and legislation. And that's exactly the same under all laws for that matter. And as a consequence, that's why Section 59 was put in place or 59(1)(a) to enable binding death benefit nominations for industry and retail funds. So when undertaking their duties, trustees must act in good faith, responsibly, and obviously reasonably. The payment of death benefits from a super fund is therefore ultimately a matter for the discretion of the trustee of the fund, unless legislation, which there is none, or the governing rules provide, which is essential. So if we go back to these slides let's have a look at a couple of things here. So I pulled up this. I'm not going to say whose deed it is, but I've got. See, let's just focus on a couple of the ones down the bottom first. So quite often the deeds that I see and review, and probably that you're sitting on, and again, James, have a look at the View Legal one, basically says that any death benefit nomination made must be in accordance with the superannuation laws. The problem about that is that there are no laws that relate to it. So, for example, if it said any death benefit nomination is to be in accordance with SIS Regulation 617A, which talks, unfortunately, the binding death benefit nominations, because they deal with industry and retail funds, they only enable the inclusion of percentages of deceased members' benefits. They don't enable, for example, the transfer of shares from the fund down to a dependent or the estate. They don't enable the transfer, for example, of farm in the fund down to the dependent or to an SMSF Death Benefits Trust. They only talk about percentages. Plus, you need obviously two independent parties witnessing it. So, but you can see there, I'm actually locking into SIS Regulation 617A, which is separate for itself. Now, I wouldn't want to do that because 617A obviously is rubbish. So it's built for industry and retail funds. So really, your death benefit nomination, if you're doing it, needs to have its own stuff. And you can see on the right, which is quite typical, and this was in Cass and Grossman, which fell by the wayside, unfortunately, because the laws or the trust deed itself, remember the governing rules, said that a death benefit nomination had to be an approved form. Unfortunately, there is no approved form. In that instance, for death benefit nominations. So as a consequence of that, the letter that was written to the trustee of the fund by the member was held not to be an approved form, and effectively the nomination wasn't binding, enabling the trustee, which was the daughter of the deceased, to pay all the benefits out to her rather than into the estate, which was to be split between herself and her brother. And effectively that was held to be A-OK. Although we did see a case recently in the Victorian Court of Appeal, which seems to go against that. But anyway, if we have a look at the top part, I've extracted this out. I just went on to look at a sample deed. Got a deed off the internet for a pretty large administration firm. And you can tell here. I mean, it's I had a look through the deed. It's just rubbish from the start to the finish. But anyway, they've got in there that payments can be made according to a death benefit agreement. Now, when I've pulled out the definition, and again, I haven't looked at this before, this was only like 20 minutes ago, so I've pulled it in and put it up here for you. Death benefit agreement means all or that part of an agreement describing the trustee's obligations concerning the payment of benefits on a member's death, which one, directs the trustee to pay the benefits to a person to whom those benefits may be paid in accordance with superannuation law. Secondly, has been executed by the trustee of the member and has not later been terminated by the member or replaced by a separate death benefit. Okay, so pulling that apart, what's the problem there? Can anyone see what the underlying problem there is? Have I taught you well? The problem there, of course, is that the benefits must be paid in accordance with superannuation law. That's death benefits. So that's a problem there, potentially, if we're trying to attack that death benefit agreement. If we argue, then we're just talking about benefits being death benefit payments, as long as they're paid in accordance with the superannuation law, then the death benefit agreement may stand on its face. But again, it's not 100% clear. So again, I would rather see that has a bit further oomph in it if we have a look at that. So what I want to do is we'll go back and we'll have a look at an SMSF will. So an SMSF will is a comprehensive contract, and it's not just on, again, the percentages. It can be dollar amounts. It's the same as a will, or it can be specific gifts, specific, whatever's sitting inside the fund, provided the SMSF members' death benefits are sufficient to meet that specific gift, they can actually be transferred out. So they indicate what death benefit payments are. I'm going to go through this and then I'm going to show you an example of it so you have an understanding. It's an overlay, as I said, it's a binding death benefit nomination on steroids. So you can still lock it over an existing binding death benefit nomination of a current deed that you might be using. But again, the preference is you've got to go in, make sure you have a look at the governing rules to enable that a binding death benefit nomination can be made. And then secondly, on top of that, it's valid at law. So it's valid at law, then you can run this on top, or the better still is to obviously upgrade to a light year docs SMSF deed. As I said before, if you're just upgrading the deed, it's only $99, but we've kept a special there for upgrading corporate trustee and also the deed if you're running that for $129. So it covers 6 core areas I'm going to take you into. Also provides a contract, which is really important. So once we do this SMSF will, it becomes part of the governing rules of the fund under Section 10(1) of the SIS Act. Section 54C, which is really important, provides then, and have a really good listen to this. Section 54C basically says that in terms of the governing rules, no one can breach the governing rules of the fund. So once our SMSF will is accepted, which includes the contract for your future administration of the SMSF estate, then it's binding on the current trustee and the future trustee. Section 55(3) says if you breach 54C, which is the governing rules in this contract that we're making between the trustee, then effectively any person can recover any losses or damages as a consequence of a breach of those governing rules. So, for example, by putting your future contract into the SMSF will, quite sensibly, and I thought it was a very smart thing to do by myself, of course, to look after you guys, that it means you're locked in as part of the administration of the SMSF will, just in relation to that client. More importantly, if the trustee doesn't enable you to do the administration, gets another lawyer or gets whoever, the advisor to the estate, which really should be you anyway if you're using our comprehensive estate planning package, Effectively, if they knock you out, you can still sue under 54C and 55(3) for recovery of whatever your fees would have been. So that's a really good one. It's no negligence. It's actually a strict liability to sue. Again, the SIS Act is brilliant in this regard, and that's what we love. You'll see that when we get to the SMSF Will, it enables reversionary pensions, or the auto reversionary pension that we were talking about with James before. And again, James, if the pension doesn't have a reversion in it straight away, you can't have an auto reversionary, unfortunately. So it just ends up rolling back, and then we have to start a brand new pension. It can be paid into an SMSF Death Benefits Trust and payments of lump sums and payments to other entities. So I've got 4 strategies coming up. I have 5, but I'm giving you a lot of strategies. What I thought I'd do now is actually take you out of here, show you what an SMSF will looks like. I'll show you the document that is produced, because the document is all important, obviously. Okay, so now you can see where I got the sample D from. I should be doing that, but I'm a naughty boy. But anyway, you can see where it is. So what I've got here is, this is stuff I've done before, but it doesn't make any difference. So I've got an SMSF will. If I go up here, you can see in my document categories, obviously it's an estate planning issue. So I'll go estate planning. You'll find it in the MOTE, the comprehensive estate planning package includes obviously the SMSF will, but I also have the SMSF will, which is down here as well for $99. So you complete that, and just like a good old, if you have a look at a good old celebrity chef, or any chef for that matter, they pre-prepare. So I've pre-prepared, so I don't have to do all the, obviously don't have to do all the signing. Again, just another thing, if you're using Chrome, which I use, you can see I've got Chrome up here. There's just a couple of little, have a look at that video, shows you simple recorrections for the site. Just need to turn off your cookies and just have a look through that. So what I've got here is, I've got the SMSF will, the document setup is SMSF will John Smith. I've used the Abbott-Family tag. For those of you who are on our system, obviously you've got your own tags. So you can put in your own white labeling there. So there's nothing really controversial about that. The member, I've got John Smith there. Date of application, 25th of the 3rd, 2020. I'll just make that, I'll take that out to now. So can't believe I'll make that the 29th of October. Members' details, we've got John Smith there, the address. You can actually have overseas addresses there if you want. Trustee, again, nothing really flash. We've got Smith nominees. We've got 2 directors there, John Smith and also Max Smith, his son. The nomination direction. Now, so this is where it starts. So I've got 6 points here. So the first one is, and you don't find these in any other binding death benefit nomination, so it's really crucial. Does the member want to revoke any earlier nominations? Yes, obviously, because you don't want them to run over. So again, I've tried to construct, well, not tried, I've constructed this very much the same as if it is a ordinary will. And so there's a lot of correlation between the two, which is very useful if you're using our MOTE, which includes the ability in one interview to do EPOAs, protectors, upgrade all the deeds, plus do an SMSF will, plus also do a will and a will with testamentary trust. So we want to revoke earlier nominations. Does a member want a reversionary pension to take precedence? So, for example, if you're using, I know Dan Butler has the precedence. If you're running this over the top of that, then you would go yes. So you go no. But my instance, I'd always make sure that the reversionary pension takes precedence. Does a member want to appoint the executor as a replacement trustee or director? Absolutely. Does a member want to include death benefit payments? Absolutely. Does a member want a professional to look after the estate upon the member's death? That's that contract I was talking about, remember? We're going to have a look at that. And do you want a catch-all? And I'll put in there, this is my nuclear option. You'll never find this anywhere. Is in the event of the fund being non-complying, that there's a catch-all clause for that. So could that reference to superannuation law, so Sally Rourke, be interpreted to mean CISA 58.1? Look, it could well be, I think, Sal, but again, I think you've been around the block a couple of times, and I mean that in terms of superannuation, it's not clear enough for me. I like everything with clarity, because if it ever gets litigated, which there's a good chance it will be, I want clarity to say this is exactly what's happening in my governing rules, exactly what's happening. And that one is probably, look, it might be 75% there, but the fact that we've got to try and dig out other areas of the law, for example, 58, which is very appropriate, just makes it a bit more difficult. I'd love to find actually who drafted that. As an accountant, are we allowed to do all of this for our clients? So the question is an SMSF will a financial product? Now, generally, a financial product is dealing with an interest inside a superannuation fund, and that's dealing with an interest now. So, for example, if I take a lump sum now, Rajiv, then what happens now is I have to be licensed for that. If I tell a client to set up a pension now, then that's, again, a financial product. If I tell a client to make contributions into a fund, then again, that is something that's happening now, so it's a financial product. Here, we're just simply building something for the future. So in my view, it's not a financial product, hence an accountant can provide this advice for that. So good question again, Rajiv, and also, of course, Mrs. Rourke. Let's go through, and again, Janice, I will contact you. Absolutely. I think if you haven't upgraded your deed in the last year, it's absolutely crucial to go out to your clients. You can find on our strategy centre, I've got an email there for you to send out to your clients as to why they should be upgrading their deed, and particularly because we've got a lot of bloodline benefits sitting inside the deed, and obviously it's enhanced estate planning. So let me get down to the death benefit payments. So I've got Sally Smith there as the spouse. Now, notice how Sally wasn't a director of the corporate trustee because she doesn't want to be. And so all she has to do is we've found, and you've, for those of you gone through our EPOA, and there was an excellent case that just came out of the New South Wales Supreme Court about an enduring power of attorney being able to effectively do an SMSF will for someone once the person was incapacitated. In that case, it was held that they couldn't, unless, of course, it was under the governing rules of the fund. So we've got that ability in there. Plus, and this is a plus, and this is why, in fact, we've got judicial now precedents that if you want to put something out of the ordinary from like normal personal health matters, for example, being able to do a SMSF will through an EPOA, then it needs to be specific. Now, for those of you who know, in our EPOA, we have in there specific instructions anyway for EPOAs to be replacement trustees and directors. So that would be the case here with Sally Smith, and also for successor directors for sole director or multi-director companies that we may have. And what I'll do is I'll do another button following this case is, do you want the EPOA to be able to do an SMSF will or binding death benefit nomination for you? So the more specificity we get into that EPOA, the better. Anyway, here we've got it's gone to Sally Smith, the spouse. She's not a director, but she's definitely a member of the fund, but she doesn't need to be a trustee. So 100% of the superannuation interest. Now, this is where it starts to happen. We need to have succession. So if she's not alive, then effectively, what can we do? So there's 4 buttons here, and we've got another. So you can always put in an external. So let me go through the first button. So the first one is if Sally's not alive, and have a look at most binding death benefit nominations, they don't even cover this, just ridiculous. The deceased estate, so it's to be paid to the deceased estate. So this would be John Smith's estate, not Sally's, for the sole benefit of the deceased bloodline or lineage, unless the SMSF Death Benefits Trust can be established under the super laws for the bloodline or lineage of the deceased member only. So if we can set up an SMSF Death Benefits Trust, remember the executor will actually be in there, then effectively what we can do is we can set up an SMSF Death Benefits Trust, otherwise it ends up the estate. The second one, so the deceased estate for the benefit of their family, and estate beneficiaries and charities. So that's pretty broad. This is a nice little one. And this is generally where you've got children who are under the age of 18 or 25. So the deceased estate for the benefit of the bloodline children of the succeeding beneficiary to be held in trust with income to be paid quarterly, but no capital distribution until they reach age 25. If there are no bloodline children of the succeeding beneficiary, then the share of my superannuation interest is to be paid to the remainder of my children to remain alive in equal proportions. The final one is the deceased estate for the benefit of the succeeding beneficiary. So I'm going to go down that one because what I've got here is, and again, if it's the children, what I might put in another bullet point, actually, just having a look at this, might put in a bullet point there to, if they're children, obviously to be paid, which is not the case here, to be paid as an income stream. Anyway, a succeeding beneficiary. So I've chosen this. So this is much the same as your primary beneficiary and then your secondary beneficiary in our wills. So if Sally's not alive, then 50% of my superannuation interest is to go to Max. Alternatively, what I can put in there, my investment, the fund's investment, sorry, I'm just leaning over, property at Coolum, Queensland. So as you can see here, I can put in shares. So as long as there's the wherewithal packaged into John's benefits, then we can go ahead and do this. So we don't need to put percentages. And so what I've done there is Max has got 2 kids, remember, Ben and William. So what I've done there is that, look, in the event that Max is not alive, then it means it's going from John and then to his kids. So unless they're dependents, so it would go into the deceased estate for the benefit of bloodline children. So that would include obviously John and include grandchildren as well. So if we then go down the track there and we go to Janine Smith, so I had 50% of my superannuation interest. I just put I just put there the remainder of my superannuation interest post the transfer of the funds investment property. Or you can put property in Coolum, so that's fine. So you go in there, and again, she hasn't got any children. So again, we could just put it back to the deceased estate. As you can see, there's quite a lot of changes there as well. The nominated professional, we've put in there. We've got, for example, this is that contract, David Jones. He's from IPS Super, and he's to be paid partner fees. So David would step in and do this process straight away virtually. So you shouldn't have to wait like 6 months. The good thing about it is you don't have to wait for probate for an SMSF payment. And you can see here, we're not paying anything over to the estate. It's going to go to Sally, or alternatively, Sally's not there, to Max and Janine. It only gets paid to the estate in the event that either Max or Janine are not around. Now, of course, we could pay to Ben and William, who are the grandchildren of John, and they could be paid as a pension. Now, importantly, we have to show, of course, that William and Ben are, although they're grandchildren, they're financially dependent upon John. And you'll see in the later slides, well, hopefully we'll get to there, in those later slides, that both of those, and we just got our meeting there, so I just want to get this, that in that instance, if there's a family allowance agreement and John is paying, for example, improving lifestyle and educational expenses for both Ben and William, even if it's partial, they will be classified as financially dependent. We had a look at James's one, which we looked at interdependent relationship, was fantastic that James raised that. But essentially what we're looking now is for this financial dependence issue that essentially there, if they can be shown to be our financial dependent, then account-based pension can be paid to the grandchildren. But we have to show that, again, they're either interdependent relationship, so for example, John cares for them, or they're financially dependent, so he improves their life financially. So we've got the SMSF will there for John Smith, and then with the Abbott-Family sign-off. I've put in a product disclosure statement. So this actually comes out, it's quite extensive. It's actually chapter 14 out of my book, The Guru's Guide to Self-Managed Super Fund. Wherever possible, prior to any legal documents, it's always great to give an explanation or a guideline from the Commissioner if possible, so they look at it. So the first step is, of course, the application by John Smith. So this is embedded. Ideally, I'd like to show you through the light year docs deed. If you want, you can just grab a sample off us to show how it works. But essentially, we've got in there specifically the SMSF will, but the member has to apply for that. And the reason they have to apply, because you can't just have an SMSF will or binding nomination say to pay $10 million and get that accepted, because obviously financially it wouldn't be that case. So we've got the fund name, Smith Family Superannuation Fund, Smith nominees. Let me just get my little annotation here so I can take you through a couple of really important ones that I've put in here so you understand. So you can see here we've got the request to accept the following nominations and directions. Again, I've put in here, although I call it an SMSF will, it's a binding death benefit nomination directions, just so it can sit as an overlay on top of another deed, for example. So when I have a look at the SMSF will for John Smith, the first one is, remember we did that, the revocation of earlier death benefit nominations, which is crucial. Our reversionary pensions are to take precedence. Appointment of the replacement trustee and member, which we did. Again, this is a contractual agreement, which is effectively part of the governing rules of the fund. So it's crucial. Perfect place to put that. Now I'm going into the death benefit payments here. So I hereby direct the trustee of the fund, provided the fund has specific assets or resources to do so, make or transfer the following benefits. To Sally Smith, death benefit, 100% of my superannuation interest. Now, look at what we've done here. So it's going to be paid to her, but this benefit may be paid as an income stream if allowed. So it would be obviously for Sally, depending on her transfer pension balance, or transferred directly to the designated beneficiary, so you can pay it directly to her, or any trust, company, person, or other entity that the beneficiary directs. So that's like not an assignment, it's like a payment in lieu, including a transfer to deceased member's estate for the asset to be held specifically for the beneficiary or in the trust for that purpose. At the direction of the beneficiary or the leading member, the trustee may create a SMSF Death Benefits Trust to hold a designated bequest. The SMSF Death Benefits Trust is a discretionary trust where a beneficiary or their assigned is to be trustee in their appointor. Further, the beneficiary is to be designated primary beneficiary of the trust, along with any lineage or such other beneficiaries as the beneficiary includes in the constituent SMSF Benefits Trust deed. The exact terms and conditions of the SMSF Death Benefits Trust are to be determined upon advice of any professional, which is you, engaged on this SMSF will to look after deceased members' super estate. Don't want to look after you guys, seriously. So what happens there is we can create an SMSF Death Benefits Trust, which is, for those of you who saw last week I did it, is classified that children under the age of 18 are taxed at adult rates. So it's covered under Section 102AG. Importantly, if you saw when I went through testamentary trust last week, and you can find that on the Strategy Centre, importantly, blending other monies into this SMSF Death Benefits Trust is not captured by the new anti-avoidance, anti-mixing provisions of testamentary trusts created upon a will. Now, if there's no designated beneficiary alive or anything, then it's to be paid to the deceased estate for the benefit of the succeeding beneficiary. But because there's a succeeding beneficiary, then we've got their son. So the fund's investment property at Coolum. So, and then again, Max can put it anywhere that they want. If there's no designated beneficiary, then it's to be paid to the estate for the bloodline children. Remember, we ticked that. For Janine, she gets the remainder of the superannuation interest. And again, she can put it in any trust, blah, 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 etc., going down that track. If there's no designated beneficiary, it goes to the estate for bloodline. Again, I'm really big on the bloodline. Nomination of the professional to review the super estate, we've got that in there. And then the nuclear option. Now, what we've done is, again, we've got John Smith, and we have a couple of witnesses there. So, and then there's a resolution by the trustee to accept the will. And then basically once that's done, that's off and running. So I'll have this and I'll put that up on the strategy center for you to have a look at. So it's pretty easy, stock standard, but it's also very, very effective, as you can see from that one. So when I have a look at here, if I just go back, I'll just close out of here. So I'll just close out of here. Let's go and have a look at the final slides quickly. So I've shown you what an SMSF will is. I've shown you how it directs everything. I'm trying to keep everything away from the estate, but I can put it in the estate where there's no surviving. So for us, strategy one is to get the succession right. So if one person's not alive, for example, a spouse, who does it go to? And if they're not alive, who does it go to? So we've now got to go down the rabbit hole, and failure to go down the rabbit hole ends up with the monies ending up in the estate and potentially subject to a family provisions claim. So if a spouse has hit their caps, you've got a pension. So again, we just need to look at who's going to be effectively a dependent, so on and so forth. So second one is important, who is a dependent? Assessed dependent, we've talked about before, somebody in a dependent relationship or someone who's financially dependent and includes a spouse or a child. Now, obviously, for tax purposes, there's a huge benefit, as we saw in Malik's case, where the commissioner tried to ping Mrs. Malik as not being financially dependent. Obviously, she wanted to take the money from her son's superannuation tax-free, obviously claiming she was dependent. The court heard that she was financially dependent because she was partially dependent and her lifestyle had been enhanced as a consequence of the payment by her son, Antoine Malik, of $50 a week as part of the board. So, and I have seen in superannuation complaints tribunal cases that just having a joint bank account between two parties is classified as financial dependence. So we talked about interdependent relationship before, interdependency, and now we're talking about financial dependency. And there's quite a lot of material on that. Again, if you go back to our 4-hour session, I went through the Commissioner's guideline on the meaning of dependency, for example, paying children's school fees or university fees would classify them as financially dependent. So that if it applies to children, it's also going to apply to grandchildren as well. And we talked about that before. Again, to bolster it, it's all very well to say, we want to have a family allowance agreement. So it's a continuous payment, which accords with Cowrie Timbers, which is an old workers' compensation High Court decision in 1938, which looked at what a financial dependency was. And back that up with a dependency declaration so that John would say, well, these are the people who are my financial dependents because I give William Smith, which is Max's son, I pay for all his school fees plus a stipend of $100 a month. So again, dependency is absolutely crucial. And remember, if it's grandchildren, they can be paid an ABP. The 25-year age limit doesn't apply, only applies to children, not grandchildren. And of course, it can also apply to brothers. As we saw before, James Barger Bross, a brother and sister, could also be encapsulated in there as well. Recontribution, how to keep the money in the fund. So remember, we took the money out and we saw that with our SMSF death benefits, it could be paid out directly to Max. Now, Max may not need the money or might have social security issues, etc. So Max could then recontribute that in subject to their non-concessional cap limits. And of course, if there's more money than is necessary, we could use that to as a related party loan. If it's property, it's 70% LVR. Collection of shares, managed funds or ETFs, it's 50% under the Commissioner's Guidelines 2016/5. So again, we can start to think of different ways to keep that money back inside the fund. For example, if it was a farm that was inside the fund, if there was no related party loan, we could use promissory notes and wheel those around. So you don't need to take cash out. You can actually use a promissory note for that. If you need help on that, again, just come to either put a support ticket on or contact me directly. Strategy for the SMSF Death Benefits Trust. I'll show you one of those probably in a couple of weeks, but essentially it's a discretionary trust and it has all the benefits, obviously, of the Section 102 AG, whereby adult children, children who are under the age of 18 are taxed as adult tax rates. Ashok, really good question. If we do, in fact, I've just seen that recently, would a related party loan count towards the transfer balance cap? We've got to be careful for that. We've got to have, it'll only go into someone's pension account. So if they're deceased, it's not an issue, but we do have to be careful of that for transfer balance cap. So that's a really good question. So let's go to the final slide. And all of this stuff will be up for you later on today. So the SMSF will is $99. Not a bad idea to upgrade the deed and also the corporate trustee at the same time. Have a look at the MOTE, the comprehensive estate plan that we looked at last week, in particular that 4-hour session, which is up on our strategy centre. Have a look at that because that forms part of the MOTE, which is my preference. So we've got a fact find in the SMSF will and EPOA and wills. That's all sitting in the strategy centre. With the client, obviously draft up the SMSF will, send it to them in a draft form, and then once they come back, finalise it. At any point in time, if it gets into a really detailed piece, what clients specifically want, either come on the support centre, or if you need to get legal advice around it, and because you're generating the documents, the legal advice isn't going to be expensive, you can come to Abbott-Family, and then what we'll do is we'll look at it and provide legal advice, and obviously then if you need be, those documents can come from us, because I know there was a question around whether accountants could do it. Absolutely. But if you want to if it's going to get a really complex area where you think particularly in New South Wales, you think there might be a challenge, then come and let us do that for you. So just engage Abbott-Family. We'll open up a client folder. We'll take your documents, finish them off, and then provide legal advice around that and charge the client a fee. So it's not an expensive process. Obviously, you'll charge the client a fee for getting the administration documents up to a certain place. So again, you'll find that there's a data capture up on the site. But look, we've covered a lot here with SMSF wills. They're so much better than binding death benefit nominations. If you have a look at it, I've been to Dan Butler's a session on binding death benefit nominations. Honestly, scared the hell out of me. Now, he's got some really good stuff inside his deed. But again, my preference is to really go the full hog, whatever the governing rules say. So if the governing rules we saw in the Commissioner's guideline says that I can do an SMSF will, put my hand up, then I'm doing an SMSF will. It's got nothing to do with the estate. It's actually just a set process and determination and directions, much the same as a will, but it applies just to superannuation benefits. Anyway, it's Grant Abbott signing off. Thank you for turning up. And tomorrow we've got a session on tenants in common and simple partnerships, which is great if you're looking at a couple of parties who have property together. Anyway, it's Grant Abbott signing off.